Easter. Abraham Lincoln once said that America will never be destroyed from the outside. If we falter and lose our freedoms, it will be because we destroyed ourselves. And I have serious concern about that, particularly a couple of weeks ago when I was in Washington, D.C., and Barack Obama's Attorney General, Eric Holder, met with the state attorneys general and said that if we didn't like our state constitutions, we could just ignore them. And I reject that, because a number of years ago I stood on the State House steps and I put my hand on a Bible that my parents gave me when I was 8 years old, and I raised my right arm to the square and I took an oath. That oath was to uphold the Constitution of the United States, the Constitution of the state of Idaho, and the laws of the state of Idaho. And that's exactly what I have done. That means that I live by and admire and pursue the rule of law. That means that the law is the same for you and I, no matter where we might be. That the law applies to the President of the United States just as it does to you and me on the street corner. That it doesn't matter whether we're the largest private employer in the state or a mom and pop grocery store on the street corner. That the law applies to us equally the same. And so that's what I have pursued. That means that when our Constitution says something that we are to do, that we do it, whether we disagree with it, whether I like it, whether I don't like it. I have taken an oath to uphold the Constitution that's actually written. I have appreciated your support in the past, and I ask for your support again in May. Thank you very much.
Thank you, Mr. Troupis. Thank you. Thank you, Dave. Thank you, Elaine, and all of you for being here tonight. My name is Chris Troupis, and I'm running for the office of Idaho Attorney General. I'm not a politician. I have not served in public office, and it is not going to be my career. For the last 37 years, I've worked representing ordinary people like you and me, and I've done that to defend their and our fundamental rights. I've defended freedom of religion, freedom of speech, freedom of political association. I've defended the right to life. For the last 12 years, I've worked in the pro-life movement, and the last 3 have been the state director of Americans United for Life. But over the last several years, I've become increasingly concerned that the federal government is encroaching steadily and more rapidly upon us here in Idaho. That the EPA and other agencies are taking away our rights and interfering with our businesses, that Obamacare has been forced upon us without our consent, and that there is a growing disconnect between the Attorney General's office and the people he was elected to serve. I'm concerned that the federal government owns 2/3 of the state of Idaho, and we have been locked out of our resources that would allow us to break the tethers of the federal government and add billions of dollars in new jobs to Idaho. But I'm also concerned that our Attorney General has rejected any efforts to reclaim those lands, even though I believe a good legal case can be made for it, and I intend to bring that case. I'm concerned that our land board has been competing with private business, and concerned that we have scorned exchanges that would put grazing lands in private ownership free of environmentalist objections while leaving them in productive agricultural use. And we could wisely invest in timber and mineral lands that would increase the monies available to our schools. I'm concerned that there are defenses to Obamacare, but the Idaho Health Freedom Act has not been defended, and I intend to do that. My name is Chris Troupis, and I ask for your support on May 20th.
Okay, this question will go first to Mr. Troupis. The state government has established a longitudinal data system that tracks students throughout their life without parental consent. Do you feel, as many parents do, that this violates a parent's right to keep their children's data private?
Absolutely. I think that the state keeps way too much information on our children. I think the federal government does as well. I think that that's one of the things and one of the reasons for that is that over the last dozen years, our Attorney General's office has placed a Deputy Attorney General in virtually every executive branch of the government. So that in fact, the Attorney General's office, which is supposed to be a watchdog over these agencies, is in bed with them. And as a result, we see regulations imposed that are in excess of legislative authority. I intend to reduce the Attorney General's office to the focus of what it's supposed to do, which is protect our rights. Our rights not only from the federal government, but from the state government as well. And do that by taking those deputies out of the Attorney General's office and allowing the Attorney General to oversee as a watchdog those agencies.
The role of the Attorney General as provided in law by statute passed by the legislature is that the Attorney General represents state government. The reason why those deputy attorneys general are assigned to those agencies is because that fulfills the statutory requirement imposed on us by the legislature. The person who upholds the law, not the one who makes the law. That's something that the legislature does. The Attorney General is bound by that statute. And that's my obligation. It doesn't matter whether I like it or dislike it. It matters that the legislature, the policy-making body, exercise their constitutional authority, pass the statute. My obligation as the Attorney General is not to countermand their will, but to defend the statutes which they have passed. That's precisely what I've done, and that's the answer in this case as well. Thank you.
This next question is addressed to Mr. Wasden, and it's your turn, so that's good. Mr. Troupis, you're certainly welcome to answer it too. It says, please clear up the confusion about the Second Amendment brief.
Oh, excellent. That's a great question. By raise of hands, how many of you have ever made a mistake? Yeah? Okay. That's what happened in my office. Someone made a mistake. I was out of town. They signed us on to a brief that was in opposition, was written by Massachusetts in opposition to the Heller case, which was a very significant Second Amendment rights case. I found out about that the next day. I immediately made a call to my office, found out that someone had made an error. I told them to immediately get us off that brief. That's a very unusual step. And within a couple of days, actually 48 hours of my directive, this document was filed in the circuit court in D.C., removing us from that brief. Now, when that case went up to the United States Supreme Court, and it went as a companion case to Heller, Idaho signed on to that brief supporting Heller. And there it is, right there. Now, you need to know that we made a mistake. When you make a mistake, what you do is you own up to it, you fix it, and you move forward. That's precisely what we have done. Thank you.
Mr. Troupis.
Yes, I certainly appreciate you owning up to the fact that you made a mistake 8 years later. But in fact, I was reading a letter that you wrote to a representative who asked you, along with 15 other representatives, to join in an amicus brief for the Sackett family up in North Idaho, whose property rights were being infringed by the EPA. You declined to write in or to join into an amicus brief, and you noted in your letter specifically that it is a serious matter in deciding to join in an amicus brief. So serious, in fact, that you consider the legal implications that that any brief that you join into, the statements made in that can be used against the state in other judicial proceedings. And therefore, you're very careful in making sure that you only enter into amicus briefs after serious consideration. It is obvious to me that this kind of mistake was the result of non-serious consideration by your subordinate, or a subordinate who doesn't believe in our Second Amendment rights. Either one is inexcusable.
Mr. Troupis, this question is to you first. What are the legal issues, if any, regarding the proposed repeal of the state health care exchange?
The state health care exchange, having been adopted by our legislature, could only be repealed either by the legislature or could be determined, if Obamacare is determined to be unconstitutional, then the state health care exchange would fall of its own accord. There are several arguments that the Obamacare is unconstitutional. The first being that under Article 1, Section 4 of the United States Constitution, that the penalties, which are the taxes, are direct taxes which can only be issued by the House of Representatives and and apportioned among the states. The second is that all tax bills have to originate in the House of Representatives, and this one originated in the Senate. Those two constitutional objections would provide us an ample basis to attack the constitutionality of Obamacare once a tax is actually imposed. And that would be the approach.
Mr. Wasden.
Within minutes of the Affordable Care Act being signed into law, I and a number of other attorneys general sued to challenge the constitutionality. We pursued that all the way to the United States Supreme Court. I have in my possession card number 13 issued to me to attend the Lawyers' Lounge in the United States Supreme Court building when that case was argued. We pursued that case all the way to the United States Supreme Court, and unfortunately, we lost. We won on a very big issue. That was, we found the hard edge of the Commerce Clause, Article 1, Section 8 of the United States Constitution. We actually have examined some of the issues that my opponent raises. We actually have had D.C. Council take a look at the issue with regard to which house did it start in. It becomes very confusing when you take a look at that. Our council's review of that indicated that we did not have a good opportunity to present that case forward. We will continue to fight that issue with regard to the healthcare exchange. It's passed by the legislature. That's their choice. That's the constitutional power they have. And my duty is to defend their choice, whichever choice that might be.